So it's been over a week since the Telegraph journalist Allison Pearson had the police knocking at her door, informing her that she was being investigated for stirring up racial hatred. Luke, there's been some recognition from the establishment that this is maybe a bad idea to have police knocking on journalists' doors. But there's also been a kind of liberal sneering about it, as if it's almost okay. What does she expect? These are the consequences of having the kind of views that she does. What have you made of the discussion in the wake of it since?
Well, I think there's been room for optimism. I think it's right to recognise that, Keir Starmer said that the police should be investigating crimes, not tweets, which is quite unusual for him to say, given he was the director of public prosecutions at a time when these sorts of prosecutions were absolutely rife.
He led the first Twitter trial, didn't he?
He led the first Twitter joke trial. And was found by the Court of Appeal to have misinterpreted the law. The CPS was under his leadership. So he has obvious form in this area. But nonetheless, there were questions asked about it in the House of Commons. There was a relative uniformity of view from most MPs that this was a bad thing to have happened. But you're right in the sense that that there has been another set of opinion, which is sort of like, well, what's the big problem here? What's the big issue? And I think to understand what the big issue is, you need to look arguably even beyond Allison Pearson's case and look at the wider environment here, where we have a combination of a few things. One is laws relating to speech, which are very, very broad. So the Online Safety Act, the Protection from Harassment Act, other pieces of legislation like this create offences that are very, very broad in their application and potentially apply to a very, very wide range of what people say online. You then couple that with the police, who are given the room to interpret this legislation and interpret the circumstances at which it's appropriate to show up at someone's house and accuse them of a crime, or in some circumstances even arrest them for a crime. So the combination of these two things mean the police have to make some really awful decisions about when to show up at someone's house and question them about an offence. And the other element of this is that when the police receive a complaint, they are duty bound in most cases to follow it through. So if someone with a vendetta spots something that someone has said online and thinks that it's offensive or grossly offensive, then they can contact the police and have that person at least have the police show up at their house, in some circumstances have them arrested. So that is a really problematic situation. And I can say that there are cases currently before the UK courts that are working their way through now, that I think would trouble most members of the public. If they saw what the substance of the complaint was, they would be worried about that. And what I think we're going to start seeing, and I've seen it reported today, that we're starting to have some of the first jury acquittals of cases involving tweets sent in the immediate aftermath of the Southport attacks. So we're starting to see juries interacting with this evidence and actually saying, no, we're not going to send this person to prison, or we're not going to convict this person because of what they said online. So thankfully, we have the jury as the sort of last bastion of liberty here. But it is problematic that the police have such broad powers, and I think their skewed focus and their skewed priorities mean they're following through with more of these complaints than ever before. And that's because it's worth remembering, policing tweets is easy. Policing theft, fraud, burglary, violence is a lot harder.
Yeah, and often doesn't seem to happen at all.
Exactly.
Michael, do you think this raises that old question of two-tier policing? And in fact, the irony is that the tweet that we suspect Allison Pearson was being investigated over was about two-tier policing, her suggesting the police were essentially posing with a group of people she thought were Palestinian protesters for actually protesting for a Pakistani political party. Does it raise that issue in your view?
I think so. I think over the 80s and 90s, and then especially with the Equalities Act in 2010, we saw the emergence of a separate category of crime, which is a hate crime. And, like Luke was saying, the parameters for some of these speech codes that may fall under hate legislation are so broad that they are subjectively interpreted by forces that we know, police forces around the country that we know are ideologically captured. We see the way they respond to pride marches, and we see the way they, wear soft gloves when they police things like the anti-Israel protests that have been making their way through the capitals each weekend, as opposed to, say, lockdown protests, or and so we know that there's an ideological bent in a lot of these organizations, and so if they're given carte blanche, it's going to lean towards protecting certain groups and not others. Like I find it hard to believe that if a minority had tweeted that a group of people on an Israel march were Islamophobes, that we would have seen an investigation like we have with Allison Pearson.
Yeah. Another issue that's also been raised by this is the non-crime hate incident. Now, Allison Pearson initially said, perhaps misremembering or mishearing, that she had been accused of a non-crime hate incident. That doesn't seem to have been the case. It was an actual crime that she was being investigated for stirring up racial hatred. But nevertheless, it has opened up this conversation. And we've learned recently, in the past week, that many children have been accused of non-crime hate incidents, including for saying one of their fellow pupils smelt like fish. Another child called another a retard. And this was logged against their essentially not quite criminal record. I don't know how your non-criminal record, I suppose. We don't even have the words to express these kind of Orwellian phenomenon.
Yeah. So what's happened over the last decade or so is that the police have developed new ways of recording things that they can't put on someone's criminal record. So by way of example, if you're accused by someone of harassing them, they can issue what's called a harassment letter. And that harassment letter will stay on the police's internal record, but it won't go on your record that's available if you have, say, a DBS check. So it won't be checkable by an employer or anything. And the non-crime hate incidents came to limelight with the case of Harry Miller. So that was a high court case where they challenged the lawfulness of this recording. And we thought at the time that was a real step in the right direction, because Miller was the case that was delivered by the High Court in Harry Miller's case was a real essay on the virtues of free speech, and was a real summation of all the reasons why we have laws to protect freedom of speech in this country.
I think that the judge famously said, we've never had a Stasi or a Checker in this country. What's going on with non-crime hate incidents? Yeah. But they carried on recording them anyway.
But they carried on recording them anyway. Yeah, exactly. So they found a way to carry on doing it. I do think that this has got to be an area for some sort of reform. I think there is a lot of attention coming on these now, and hopefully the Pearson case will, although you're right, it wasn't an allegation of a non-crime hate incident, but hopefully this will be a hook to get these back into the public discussion. And so we, as part of a broader debate around reassigning police priorities to crimes rather than non-crimes.